Hello. Private hunting grounds were medieval England's ultimate status symbols, set aside to be enjoyed only by royalty and the aristocratic elite. Saxon nobles hunted. After the Norman Conquest, several royal forests regulated by forest law were designated by William I. A select few of the most privileged earls enjoyed similar rights in chases. Referring to the setting up of royal hunting forests, the Anglo-Saxon Chronicle said of King William, "He made great protection for the game, and imposed laws for the same, so that those who slew hart or hind should be made blind. He preserved the harts and boars, and loved stags as if he were their father." According to a treatise written around 1180 by a court official, Richard Fitzneal, on the workings of the Exchequer, set out in question and answer format, royal forests were places where monarchs could lay aside their cares now and then to hunt as a rest and relaxation, a getaway from the anxious turmoil of the court. As well as recreational sport, chasing down game had practical and economic benefits. Hunting was a way of keeping men and horses fit for battle and providing a supply of food and other materials. Every bit of a deer was used, from the hide to the teeth and antlers. Venison was a luxury and a useful gift to reward supporters. I should say that forest in this context was a legal term. It does not necessarily mean densely wooded, as in the modern understanding of the word. Deriving from Latin foris, meaning outside, a royal forest would typically contain a mix of coverts and open countryside. In this sense, the designation royal forest defines an area regulated by forest law set aside for the protection of the beasts of the chase. Collectively, the venison, native red and roe deer, supplemented by imported fallow deer, and wild boar, treated as a kind of honorary deer, and the vert, the vegetation that sheltered and fed the animals. A hierarchy of officials, verderers, rangers, wood-reeves, stewards and foresters under a chief forester upheld forest law. Many posts became hereditary, passed down from generation to generation. This sketch of a grave slab in St James Church, Papelwick, Nottinghamshire, is carved with the symbols of a royal forester, a bow and hunting horn. Local woodmote or swanimote courts dealt with offences. Every few years the King's justices would arrive to collect fines and hold assizes known as Forest Eyres to clear outstanding cases. Court records show offenders span society, from peasants to clergy and members of the gentry. Forest law, codified under Henry II in 1184, was brutal in theory. Poachers potentially risked blinding, castration or the loss of a limb. In practice, the common penalty was a fine, although a hound involved might not be so fortunate. In his Charter of the Forest of 1217, Henry III stipulated, "No man from henceforth shall lose either life or limb for killing our deer." Instead, a fine was to be levied. If unable to pay, the penalty was imprisonment for a year and a day. If sureties could still not be found at the end of the sentence, the punishment was exile. Offenders could be taken dog draw, that is with a hound chasing down a wounded animal. Stable stand, caught with bow and arrow poised to shoot, even carrying a bow in the royal forest was an offence. Back bearing, carrying a kill, or bloody hand, literally red-handed. Forest courts were mirrored in private chases by seigneurial courts, but with more limited jurisdiction. Serious offences had to be referred to the civil courts. Fences, banks and ditches and gates marked the boundaries of chases and royal forests, remnants of which often survive in the landscape. Maintenance of the bounds might be a requirement of those living within the forest, who typically benefited from a range of customary usage rights, such as the right to pasture livestock at certain times of the year or to collect firewood. Any dogs owned might be required to have their claws cut. When Domesday Book was compiled around 1088, there were some 25 designated royal forests. By 1215, when Magna Carta was sealed, The number had risen to nearly 150, and dissatisfaction with the contentious system of forest law was one of the causes of baronial unrest. Henry III's Charter of the Forest of 1217 effectively ended the creation of new royal forests, but forest law remained on the statute book until 1817. Next time, keeping the peace locally and punishment in stocks or pillory and at a whipping post. If you've enjoyed this video, hit the like and subscribe buttons and click on the notification bell to be informed when the next video is available, or you can subscribe by clicking on the rose window over my shoulder.